All states have statutes permitting domestic violence victims to obtain some form of protective order to safeguard against further abuse. But family violence can take many forms beyond physical abuse. Do existing statutes account for this reality? Or is physical violence or a threat of violence necessary to support a protective order? That's the question in Cavanaugh versus Cavanaugh. Rosanna and Brian Cavanaugh were divorced and shared physical custody of their only child. On multiple occasions, Brian had screamed and sworn at Rosanna and placed her in fear of bodily harm. Their relationship worsened after Rosanna filed a motion to modify their child's visitation schedule. The family court dismissed Rosanna's motion. Thereafter, Brian called Rosanna 3 times to swear at her and gloat about the family court result. The last phone call occurred while Rosanna was on her way to meet Brian to pick up their son. Rosanna became frightened after this phone call and obtained a police escort to pick up the child. Following the 3rd phone call, Rosanna filed a complaint in family court seeking a protective order and asserting that Brian had placed her in fear of imminent physical harm because of his threatening, swearing, and menacing behavior. The court issued a temporary protective order and set a hearing on Rosanna's complaint before a magistrate. Both Brian and Rosanna testified at the hearing. Brian admitted to the phone calls and acknowledged that swearing at Rosanna over the phone constituted harassment. Finding that the case didn't involve physical violence or threats of physical violence, but rather harassment, intimidation, and control, the magistrate issued a civil restraining order. The chief judge of the family court affirmed. Brian appealed to the Rhode Island Supreme Court, arguing that the family court exceeded its statutory authority because the magistrate hadn't found that domestic abuse existed.